client service as a niche law practice. We are conscious of the demands of our clients. We always offer a friendly, listening ear and sympathetic attitude. We've worked with thousands of people all across the UK in all areas of personal legal services. We have received great feedback, reviews from our clients. We are located at Seven Sisters in Tottenham on the 4th floor of the Anna House, right on top of the Victoria Line train station, with utmost convenience. We have a friendly office and provide all of the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence, and conduct as part of our responsibility to uphold the rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society accreditation helps to demonstrate that we have obtained the requisite standard in the area of law and have the requisite expertise. BWF Solicitors, we're here to help you with your legal services when you need us.
Victon Estates provides professional and reliable service to landlords, investors, and tenants. Our mission is to ethically and honestly serve our clients. We won't make promises we cannot keep, rather. We present a clear picture of the reality we can offer. We are here to help you with long and short-term let, property management, cash buyers for quick sales, stop repossession, and mortgage arrears. For all your property needs, look no further. Visit us at www.victonestates.co.uk or call us on 07448619711. Victon Estates, your property is our pride.
Hello, ladies and gentlemen. You are welcome to Heritage TV, the Legal Hour with BWF Solicitors. I hope you had a lovely week. Yes, we also did, and I believe you are all keeping yourself safe and protecting yourself from what is hovering around us, which is the COVID. As usual, today we have our ever faithful resource person from BWF Solicitors with us, who is going to talk to us about applying to remain in the UK based on your private life. May I also remind all of you to send in your questions on all our social media handles, both on Heritage TV platform and BWF Solicitors platform on Facebook, YouTube. And we will be able to pick up those questions and discuss it on the show. I think we will encourage each and everyone watching us to tell their friends, family, and colleagues to tune in, because this is a very educative program. It might not relate to you, but definitely it might help somebody close to you. So please share. Right. So without wasting much time, I would like to introduce Mrs. Champon, who is a solicitor at BWF, also one of the partners at BWF. Hello, Lawyer Eunice. You're welcome.
Thank you so much. Thank you, Vicky. I'm doing well, and I'm loving your hair as well.
Oh, okay. And I think my top is your hair. So
yes. I know, right? We need to do a swap, but we're all complimenting each other, so it's good. Hope your week was good as well.
Yes, it was great. And as usual, before the program, we do share on all our social media handles, advertise. I think BWF does that as well.
Yes.
Telling everybody what to do this Saturday. And oh my, the messages I'm receiving, people are very keen to know what Lawyer Eunice have got for us.
That's good.
So I believe, as you always do justice to all the topic, we are here today, and definitely not going to disappoint us. We're going to do justice to our topic for today, which is applying to remain in the UK based on your private life.
Yes.
Lawyer Eunice, what is private life? What is private life? Life with no interference from the government, or I don't know. What is private life?
Okay. Before we start, I just quickly wanted to say happy birthday to my pastor and daddy, Pastor Claude. Today's his birthday, and I just wanted to wish him an amazing day. And we pray for God's manifold blessings over his life and his family's life, and that the Lord himself will continue to direct him in wisdom and with knowledge and understanding, and that the path that he has chosen in ministry will forever be fruitful, and the Lord will prosper his ways. So, Pastor Claude, happy birthday. Sorry, I had to do that because I know that he's always supporting me as well. So I just quickly wanted to throw that in there. Okay, so when we say private life, what is private life? And I remember when I was in law school, and because we were part of the EU, you have to do EU law. It's a mandatory, one of those mandatory subjects that you had to do. And then you had to learn about human rights as well within that module. And so you had all these different human rights that were enshrined within the European Convention of Human Rights. And of course, one of the rights under the Human Rights Convention was the right to respect for private and family life under Article 8. And so usually when you look at the human rights, you have those that are absolute and you have those that are, should I say, restricted or limited. So that means that if it's restricted, then the government of that member state can obviously interfere with that right, like you were saying, and one way or the other. And you have certain rights that are absolute. So the right to life, that's an absolute right. And so that cannot be interfered with by any government whatsoever. And then you have our right to private and family life under Article 8, which is not absolute, so it's restricted in some form. And that means that the government has a way, or should I say, it can interfere with it if it meets a certain legitimate aim that they should have. So, for instance, yes, somebody has a right to respect for private and family life, but if they commit a crime and the government thinks that they are within their rights to also remove that person from this country because of the crimes they've committed, then of course they are meeting a certain legitimate aim, because they feel that the public interest in removing that person outweighs the person remaining in the UK. So regardless of how long the person has been in the UK or the ties that person has built up whilst in the UK, they feel that the public interest is to remove this person because unfortunately this person's conduct or behavior is not conducive to the public good. And so they feel that they can interfere with this person's right. And so, of course, when you have somebody who is in that situation, then it becomes very difficult, because it means that the national or the government of that country can decide when to let a person stay or leave, regardless of the rights that they have to private and family life. And so something like that will be seen as a negative if interference. Whereas if somebody has a right to respect for private and family life, and they're asking for leave to remain in the UK, and then the government says, oh, okay, we've seen that you have built certain social ties, you've established well-grounded ties with your community, you are somebody who is of good character. We know that you've done so many things around maybe you have volunteered in so many different ways within your community as well. And so we think that you're somebody who we would like to grant leave to remain. And that's a positive interference with that person's right to respect for private and family life. So yes, the government can either have a negative interference or a positive interference when it comes to rights that are restricted or limited in some way. And so when we talk about private life, we're talking about somebody's right to obviously establish social ties, to be able to, even when you say somebody's religious background, that also forms a person's private life. Somebody's gender is also part of their private life. When you talk about even race, the fact that somebody has a different color to somebody else, that is also part of that person's private life. Somebody's political views, their personal beliefs, all of that forms a person's private life. And so apart from the family life that the person may have, all these psychological things and a person's physical attributes all form a person's private life. And so all these things under case law also help to ascertain who and what a person's private life is. And so basically under our immigration rules as well, you have what the UK government will also define as a person's private life as well. Yeah.
Categorize people who want to apply for the private life.
Okay, so as I was saying, the UK government also has what they would define as a person's private life. And if you look specifically at our immigration rules under paragraph 276 ADE, it has categories of what they believe to be private life. And so you would see that under paragraph 276 ADE, it talks about the fact that the grounds for which a person can apply based on their private life is if that person can show that they have lived in the UK continuously. So it's continuously for a 20-year period. And if you look,
20.
yes, 20-year period, yes. If they are above the age of 18 or they are 18 and above. And if you look at what continuous residence is, of course, continuous residence is to show that you have been here for an unbroken period of time. And considering the period of time that we're talking about is 20 years. And I know that before July 2012, people had the benefit of applying for long residence after 14 years living in the UK. And now you don't even have that anymore. So you have 20 years. And of course, with the 20 years, you'll be granted that 2.5 year leave for 10 years before you can even apply for indefinite leave to remain. So people who were, should I say, lucky or blessed enough to make applications before the 9th of July 2012 had the benefit of applying for indefinite leave after 14 years. And that was great. Whereas now, most people will be given a limited leave to remain before they can eventually apply for indefinite leave to remain after 20 years. And so obviously, you have people in such situations having to prove that they have indeed lived here for that continuous unbroken period. And usually you would have to show that you haven't had any period of absences for 6 months or more within that period. So somebody who has lived there for that continuous period of 20 years and who is above the age of 18, you have to be able to show for that period of time that, yes, I have lived here. And you have to also show, of course, that you haven't been out of the country or absent for a period of 6 months or more. And so usually when you're showing the evidence, you're not just showing one piece of document for every year, but you're having to produce evidence for at least every should I say 4 or 5 month period to be able to show them that you haven't been absent from the UK. Because unfortunately, if you have been absent for a certain period of time, so let's say you're not able to produce evidence that you were here throughout 2012, and the only evidence you have is December 2012, they're going to say there has been a break in your period of leave, and therefore your continuous residence will start from 2012 December, because from that date we can see that you have lived here continuously. But if before that you can't produce evidence for a period of 6 months or more, then it means that your period of leave has been broken, and therefore we will have to start your 20-year period from December 2012, and that will be so harsh. So of course, they have said to you that once you have lived here for 20 years, so it can't be before the 20-year period, the application has to be at the 20-year period date. And then once you can show that you've lived here for a period of 20 years, then of course, you can then make the application with evidence that you have been here and you are able to show. Maybe you have evidence of your boarding pass. It's amazing how many people still have their boarding pass from 20 years ago. And some people are also able to show their passport, date of entry into the UK. There are people who also registered with GPs and the rest, and they can also go and get a letter from the relevant GP surgery to show that they were registered when they first arrived in the UK. So there are different things that people can also show to obviously evidence the fact that they've been here for a 20-year period. And if you have friends and if you have, should I say, churches or mosque and other associations or community activities that you do, people can always write relevant letters to show that they have known you for a certain period of time within the 20-year period. And obviously that can corroborate the evidence that you are giving to the Home Office to say that you have been in the UK for a continuous period of 20 years. So that's for somebody who is 18 and above. Then you have somebody as well who may be above the age of 18, but under the age of 25. And if somebody like that is making an application based on their private life, you have under paragraph 276 ADE that person should be able to show that they have lived in the UK for more than half of their life. And so, for instance, you have a child who came here at the age of 8. They've lived in the UK, attended school, gone to college. Now they want to make sure that they are able to go to university, and they meet this hurdle because they are not able to show what their immigration status is in the UK. And so in that case, what does that person do? We thank God for that provision under our immigration rules, that somebody who is above the age of 18 but under the age of 25 can make an application based on their private life if they can show that they've lived here more than half of their life. And so a child who came here when they were 8, living here more than half of their life means that they've lived here for more than 8 years because they came here when they were 8. So for instance, if they are now age 17 or 18, that means that they've lived here for 9 or 10 years, and therefore they can show that they've lived here for more than the 8 years that they came into the UK. On that basis, if they have evidence from schools or colleges and hospital, GPs, the rest of it, any letters to show that they've lived here continuously for that period of time, then of course they can make that application based on the fact that they have lived here for more than half of their life. And regarding those two categories, you should be able to show that there hasn't been any period of imprisonment as well. So in cases where, for instance, somebody has been imprisoned because they committed an offense, so maybe they were sentenced to 6 months, or maybe they were sentenced to 1 year in prison. If you are making an application based on your private life, the period in which you spent in prison will be discounted. So that means that that period will not be counted towards your 20 years, or will not be counted towards half of your time here in the UK. So if you are saying that you have lived in the country for 20 years and then you went to prison for a year, then they would take that 1 year out. So it means that in essence, you have actually lived here continuously for 19 years. So of course, sorry. Punishment. Well, they're trying to tell you that they don't like it when people have committed offenses for which they have actually been convicted. Yeah, so you can call it a form of punishment. Yes, in a way, they are punishing you for the fact that you've already served your, shall I say, your criminal sentence, and they're now trying to tell you we'll also punish you further under the immigration rules. So yes, that can also go against somebody who has been convicted of an offense. And usually, of course, when you have a deportation order, usually people who have deportation orders under our suitability requirements, those people automatically, your application will be refused, because those are one of the mandatory reasons for refusal. If you've been given a deportation order, so for instance, you committed an offense and then you were convicted for a period of 12 months or even more. And of course, in this country, if you're a foreign national and you have been convicted of a criminal offense for which you receive a sentence of 12 months or more, you are definitely likely to get a deportation order. And so once that has been served on you, it makes it very difficult for such a person to even then apply based on their private life. So they see you as a foreign national, you don't even have immigration status in the first place, you've committed an offense for which you've been convicted for a period of 12 months or more, then that means that it is very less likely that they would even consider your application, because under our suitability requirements, that is one of the reasons for which a person's application will be refused. And so, of course, because it's a mandatory refusal, they wouldn't even bother looking at the application whatsoever. But in a case where, for instance, you committed an offense and you have been sentenced for, let's say, 6 months, and you have been convicted of that offense, of course, they will consider the fact that you were sentenced for 6 months and they would discount that period. And so, of course, you should be very careful as to the life that you lead and the behavior and your conduct whilst living in the UK, because they don't just want anybody whatsoever to be granted leave to remain. They are also looking for people with good character who will add to society and not take away from society. So those are some of the things that they look at. And then coming to our third category of persons who can apply for leave based on their private life, you have somebody who can show that they are under the age of 18, that they have lived in the UK continuously for a 7-year period. And then this is the only one with a condition that you can show that it would be unreasonable for this child who is under the age of 18 to return back to their country of origin. So, of course, if you are a child or you were born in the UK, as we all know, a child that is born in the UK is not automatically British. So if you're a child and you were born in the UK and none of your parents were settled or British at the time of your birth, then usually what happens is that when the child has lived here for a continuous period of 7 years, that child has then formed private life in the UK because they do not know any other home as their home. And so this is based on case law, because if a child has lived here for 7 years of their life, then this will be a place that they will consider to be their permanent home. The friends that they have at school and the social ties that they have formed forms very much their private life. And so a lot of children who are in this situation would be able to apply for private life based on the fact that they have built these social ties, they have come to know the UK as their permanent home, and they would not consider any other place as home rather than, let's say, the UK. So in cases like this, it means that it becomes necessary for the child to be able to apply for leave to remain based on the private life that they have built up in the UK. And of course, their cultural ties, the way that they speak, the way that they do things is all based on their British way of life. I once had a client and she said her daughter was born in Ghana, but it is so it's so funny how this girl, it has become so accustomed to life in England that even when her mom is speaking Tree to her, she will speak back in English. And her son, who was born here in the UK, would speak English and then speak Tree when he wants to. But the one who was born in Ghana, she doesn't want to speak the Tree at all. She just wants to speak English. And I said, it's amazing how children can behave. So yes, when a child has lived there for that period of time for 7 years, it is fair to say that, of course, that child has established their social and their cultural ties here in the UK, and they are very much British. And so, yes, we have different case laws that look at why it will be unreasonable for such a child to return to their country of origin. And it also gives the government some form of positive interference in a person's private life. And so those are categories of private life applications that can be made under our immigration rules. And it's good that at least we know some of these routes, and then those that obviously will benefit from them will be able to make preparations towards that as well. So if it means gathering evidence and putting things together to show that continuous period of residence, then of course that should be done, so that as much as possible, once your 20 years is up, or once you can show that you've lived there for more than half of your life, or that your child has lived there continuously for that 7-year period, then they will be able to make that application and have the leave granted to them as and when it is due. Yes.
See, when we're talking about 2 years, I'm just a scenario.
Yes.
No can make any assumptions to this, assumptions to this scenario.
Yeah.
You arrive in the UK, you were 40 years old. You were not able to regularize your stay, so had to stay on for that 20 years. Apply. So by that time, so 60 years, then you have to do the 2.5 another 10 years before you get to end, so you are 70. And when you get to 60, within a few years, more than 7 years or so, you are retiring. Then by the time you get into you are 70. No, Eunice, can't hold off it with the exceptions to, according to your age. Because
I think is one of those scenarios which come to the extreme end of somebody's, should I say, life here in the UK. And when we talk about our immigration rules, a lot of it has to do with the fact that they want to create a hostile environment as well. So you should always have that at the back of your mind, that since the Conservative and Liberal Democrats came into government in 2010, one of their main intentions was to create a hostile environment for immigrants, to reduce immigration.
These immigrants want most of the jobs. Look at the NHS.
Yeah.
Look over all the jobs. You go to offices.
It is very true. And I think that a lot of the time, maybe people in government believe that because these people who work may be on the black market, so maybe they are not paying taxes, but they are working. So unfortunately, they want to curtail these activities. And yes, there is provision for people who have lived here for less than 20 years, but it's also another difficult hurdle. So if you are able to show that you've lived here less than the 20 years, but you are above the age of 18, but you are able to show that there will be significant obstacles to you going back to your country of origin to make the application, then of course, you can make the application from the UK, and they consider a number of different factors. So they will not just consider the fact that you've built up private life here in the UK. They are considering what obstacles are challenging to you back in the country where you are from. Is it political difficulties? Is it to do with your sexual orientation, for instance? Is it to do with your religious background? So they will be considering all these things and what the risk is, or what the harm will be towards you if you were to return to your country of origin. And like I was saying last week, in terms of our partners and what they can show as significant difficulties, or what they can show to be insurmountable obstacles, this is also another high threshold. And if you cannot show that you are going to have some form of significant obstacle to you returning to your country of origin, then unfortunately it will have to be the 20 years. It's very rarely that people are able to show that there will be some sort of significant obstacle to them returning to their country of origin to make an application. So if you are in one of those categories where you think that there is some significant obstacle based on your religious background or your political affiliation, or even to do with the chaos or should I say harm that you will face if you were to return back to your country of origin, then of course you need to show evidence of that to be able to make the application if you have spent less than 20 years in the UK. So yes, there is the opportunity to do that, but there's also that high threshold to meet if you've been here for less than 20 years. Yeah.
Just join the Legal Hour show with BWF Solicitors. And today we're talking about applying to remain in the UK based on the private life. And with me is Laura Eunice Achampon, who is a seasoned solicitor with BWF Solicitors, also a partner at BWF. I'm going to send me a question. You get questions that will be able to make the program more interesting, more fun. So I would like to, I want to hear from you. So send me your question. Now, this questions are started coming in. I've got one question from Queen. She says, I have lived in the UK for 18 years and have not been in the UK. The only thing I have in my name is the GP surgery I registered with. When I first arrived in December 2002, I have been working with someone else at the NI. Would it be possible to apply for leave to remain with the payslips, P60s, and letters from the employer?
Okay, so in her situation, previously I was saying that when you're making an application, you need to make the application once your 20 years is up. So she says she has been here for 18 years. So of course, she would need to have lived here for that 20-year continuous period to be able to make the application that we are talking about under paragraph 276 ADE. And then she also mentions the fact that she also has her name for her GP records, but for her work and other things, unfortunately, she's been using somebody else's identity. So when it comes to proof of your residence and the fact that you need to be able to disclose also to the Home Office for the reasons that we've put forward. So for instance, you say you've lived here for a 20-year period and you've used other names, for instance, that is one of the questions that will come up when you are even making the application, whether you've used a different name prior to the name that you're using. Because all of these questions will come up, you need to be able to disclose to them that this is what the case is. And under our suitability requirements, you have those that are mandatory reasons for refusal and those that are discretionary reasons for refusal. And if for... Sorry.
If you declare, then wouldn't it be against, wouldn't be a disadvantage if you declare that you use someone else's identity? Because it's an offense.
Yeah, it's a criminal offense. Yes. Yeah, it is a criminal offense to should I say use somebody else's identity. That's what we usually say is an imposter. So it is a criminal offense. And of course, when it comes to the immigration rules, under our suitability requirements, you have clearly written there that if there has been use of any representation or information, or you have given them any sort of false documentation in relation to any application that you are making to the Home Office, of course, they may refuse your application. And that is one of the discretionary reasons for refusal. But if you are able to say that, yes, of course, I used this person's name, I was using it because I didn't have any immigration status and I used it only for the purpose of working, yes, they know that it's a criminal offense. However, you are using the evidence that you have accumulated to show that you have lived here for a period of 20 years. And this is by way of case law as well. So we have cases like Mahmood and other cases where the applicants or the appellants in those cases were able to show that, yes, they used these other identities or false identities whilst they were here in the UK. they are not the people that they are said to be in their places of employment or whatever it is. But because of the fact that they have to show that they have lived here for that continuous period, and that is the only evidence they have to show, they are therefore presenting these evidences by way of showing that they have lived in the UK for a continuous period of 20 years. And so, yes, the suitability requirements will come in, but because it is a discretion to the Secretary of State whether to allow or to refuse the application, once these cases have come into play, like in the case I just mentioned in Mahmood, the upper tribunal was very, should I say, favorable to the appellant and said that, of course, the appellant has disclosed all of these facts to you, and they haven't in any way said that they were imposing themselves as they being that person. They are telling you that they used somebody else's identity, therefore there was no false representation, there was no false documents, because of course the P60s and the pay slips were produced legitimately by the employers. And of course, all these things go on to show that because they have made such disclosure and there was no false representation whatsoever, you should therefore grant them leave, because these documents are not false, and they have also clearly shown to you that they are not the person that was put on this, should I say, pay slip or that P60 that they were producing, but they were using their documents to be able to work here in the UK. So yes, if he or she was in that situation and would want to make the application based on their private life, they can use evidence that they have produced from using that false identity to be able to show that they have lived here for that continuous period of 20 years. So yes, they can make the application for further leave to remain based on those evidence.
So that is one where you has answered your question. So I believe that if you want to start preparing your application, I'm advising you to start learning this. You have to take steps for that. And then the show you names available. Contact you. Coming, you also let me. And I now have 3 children. They are 8, 7, and 3 years old. At one point, I tried applying for and it was unsuccessful. My mother has a yes now, and I would really like to go back to see her. Can I go for the children so that I can also be granted leave to remain? Right.
Okay, so in relation to this question, it's in 2 parts, because you have the children, and from what the question is saying, it seems like both parents don't have any immigration status. And so the children who are 3 children, I think there's one that's 8 and another that's 7, and there's a younger child. And so, of course, they're looking to see if those children can apply for leave to remain, and then if the parents themselves can also apply for leave to remain. So usually you have a lot of parents also in this situation. And if, for instance, a child who has no immigration status can show that they have lived here for a continuous period of 7 years, as I was saying earlier, then of course they can make the application based on their private life. And so you have cases like KO Nigeria and ET where children who have made applications based on their private life and the fact that their parents also may have had very adverse immigration history. And because, of course, these parents are also taking care of these children. And the fantastic thing about children when it comes to applications like this is the fact that the Home Secretary also has to consider the children's best interests. So you have under Section 55 of our Borders and Immigration Act that they have to consider the children's interest as paramount or as primary consideration. So what is the best interest for this child who is 8 years old? What is the best interest for this child who is 7 years old? And if case law is saying that by the time a child is 7, they have built up their ties, such as their social ties and their cultural ties here in the UK, then of course the best interest for these children is to continue to remain in the UK. And so because we have different case laws, these children's applications under our paragraph 276 ADE is more likely to be successful because, of course, if they can show they've lived here for that continuous period by way of school letters, letters from GP, their personal health record book, all these pieces of evidence can be put together to show their continuous period of residence. And once the application is put in, not forgetting the parents, because you can do those individual applications so that they are all submitted together. So once those applications are submitted, then you can go ahead and say that, yes, the children have been able to show evidence of living here continuously for a 7-year period. And as parents, we are the ones who are responsible for these children. So under Appendix FM, you are saying that you have parental responsibility for these children. Of course, you have the children who normally live with you, or you have sole responsibility. But in this current situation, there's 2 parents, so they have joint responsibility for the children. And by way of evidence, they are showing 10 parents' evenings, for instance, or they are listed on the school's database as next of kin or emergency contact. So all of this will help in making the application stronger. So it helps that you can put all of those evidences together and then make the application for the children and the parents as well to be granted further leave to remain in the UK.
If one of the children is the age of 7, because child is old.
So the child who is under the age of 7 can still make the application, but in line with the parents' leave that will be granted. So under Appendix FM as well, you have category for a child who is making an application based on their parents. So if the parent, let's say, is applying for leave to remain based on the other children who have lived there for 7 years or more, then the child who is less than 7 will be able to also make the application in line with their parent who is making an application for further leave to remain. And so they will be granted leave in line with what their parents will be given.
All right. Wow. Yes. The next question is also coming from Lily. I came to the UK. No, Lily. I came to school in the UK and attended 6 months of my A levels. Before I could start my first year of uni, student finance wrote to provide my immigration status in the UK. My uncle tried applying for British citizenship for me, and it kept me confused. I came to the UK 10 years old, and I'm now 21 years old. How do I go about applying for leave to remain?
So in a case like this, you have somebody who, like I was explaining, has come to the UK from a very early age, but unfortunately has not been able to make any headway in terms of their immigration status. So in such a case, they would have to show that they've lived in the UK for more than half of their life. And so you're saying to the Secretary of State, or you're saying to the caseworker that, yes, I've lived in the UK for more than half of my life, because when I came, I was 10 years old, but now I'm about 21 or whatever age the person is. And so in that case, you are saying that because you have lived here for more than that 10-year period, or you've lived here for more than 10 years, because of course, when you came, you were 10, and now you are 21 years old. And so you've lived here for 11 years. So, of course, if you can show by way of evidence that you've lived here continuously for more than half of your life, then you can make the application by producing your evidence, whether it's school letters, school certificates, if you've done your GCSEs, letters from GP, hospital, any other form of letters. If you have any bank statements, you can include those as well. So all of these can go towards showing that you have lived here continuously for that period of time. And then, of course, once you are making that application, you should be making it showing that you have a valid passport or identity, and you will have to also enroll your biometrics as part of the application process. And because most of our applications are now done online, once you have submitted the application, you pay the immigration health surcharge as well as the application fee in order to make the application. So yes, she can go ahead and make the application online, and then pay the required fee, including the immigration health surcharge. And then, of course, the documentation will be needed once they have booked a biometric appointment, and then they upload that to the system. So yes, of course, that application can be made here in the UK as well.
Successful, how many years will she be given?
So usually you'll be given a period of 2.5 years. So all the applications made under the private life route are made with a grant of 30 months, which is 2.5 years. And if those applicants are able to show that they are able to meet those same requirements for a 10-year period, then they can apply for indefinite leave to remain after a period of 10 years. So yes, in those categories, unfortunately, there isn't any 5-year route. So you remain on the 10-year route to getting your indefinite leave to remain. Somebody also asked a question here. It says that, good morning, please, my question is, can someone with limited leave to remain 10 years route through his child get access to student loan if he wants to go to uni? And so I said, let me just chip that in, because of course, many people would be in a situation where they would also want to go to uni. And it depends on the course you're going to take as well. So if you are going to do an undergraduate course and you want student loan, there are certain requirements that you need to also meet in terms of your student loan. And student finance have their own eligibility requirements and what you need to meet. And so one of the factors that they need met is the residence requirement. And a lot of people usually fall foul when it comes to the residence requirements, because they don't just want you to show that you've lived in the UK for 3 years, but you have lived here lawfully for a 3-year period before making the application to be granted student loan. And so most of the time, if you have been granted 2.5 years, you don't just make the application to student loan, because unfortunately you don't meet the 3-year lawful residence. So if you have been previously granted 2.5 years and you're on your second period of leave, then of course, if you have been given 3 years leave, or you have remained lawful in the UK for a period of 3 years, then you can also make the application to the student finance. And it wasn't always so. This is because we have cases like Tegiri that gave people in this country who have leave to remain the opportunity to also apply for student finance. So yes, if you have lived here lawfully for a period of 3 years and you are making this application to student finance, of course, you can give them a call as well, and they will tell you what they need from you before you start the application process online. Yeah.
She's flowing us fans on Facebook, so I'd just like to give her a shout out. I think my Eunice, there's another person on the BWF Facebook platform. The gentleman is asking the question to please take us through it. Simon Johnson.
Okay. So it says, please, I've been here in the UK since 2008. I was given EA family permit or EA family member, but unfortunately, my EA rights were revoked when I was applying for indefinite leave to remain. So they asked me to go back to Ghana, but I didn't go. And I married an EU national, and now I've got 5 years again. Please, my question here is, since 2015 till now, I've not been able to travel. So please, what basically should I do to apply for leave to remain? Okay, so I'm thinking, because he was previously married and now he has been able to find another EU national to whom he is married to. I'm not sure whether he divorced the previous EA national partner. So I'm hoping that he was able to make the necessary divorce before he married this current one, if I'm understanding his question correctly. Unfortunately, we don't have a telephone line that I could say that he can call and clarify his question. But if I'm understanding him correctly, because he's now thinking, can he travel? Because he says he now has married another EU national, and he's got 5 years again. So since 2015 up to now, he hasn't been able to travel. But I'm wondering why he hasn't been able to travel. That's, I think, the main issue. Because if you have 5 years residence card, you should be able to travel just like anybody else would be. And usually a biometric card that has been revoked will no longer be effective. So in essence, to you has been curtailed, or you can no longer rely on that right to be should remain in the UK because they don't believe that you're a family member of such EA national. Yeah. So in this case, if he has married another EA national, then of course he should be able to show that the previous one, he is divorced from that other person and he's now married to this EA national from whichever country that person is from, and he's making the application under the EU settlement scheme for limited leave to remain, depending on the date of marriage, because I'm not sure when they were married as well. So if they were married since 2015, then they've lived together in the UK for more than a continuous period of 5 years. So under our EU settlement scheme, you should be able to show that you were a family member before 31st December 2020. And if he is able to also show that he's lived here continuously for a 5-year period, then he would be granted indefinite leave to remain or settled status. So of course, he can make the application under the EU settlement scheme for that indefinite leave to remain, and then show by way of evidence that they've lived together for a continuous period of more than 5 years. And if his current partner has also already done the EU settlement scheme, then they will ask for the UAN number, which is the unique application number, and then they will cross-reference those applications when they are making a decision for his application. So yes, if he needs further advice, he should not hesitate to contact us after the program as well. So I would definitely give the details for him to make contact.
Okay. All right. Okay. So in the absence of any further questions, I will let Lawyer Eunice give us her last words and any advice. And may I also remind people, please, 30th of June, deadline.
Yes.
30th of June.
Yes.
Lawyer Eunice has been mentioning this. We've had several programs on that. We are almost coming to the end of May. And up to 30th of June. So please, Lawyer Eunice, could you please give us your last words and your contact details? And may I also ask our viewers, those who have been calling Lawyer Eunice's mobile phone during working hours, please, that mobile number is for out of office hours, for emergency purposes and out of hours mobile number. So please, during working hours, we will advise you to call the office number. Please call the office number and Lawyer Eunice will definitely get back to you. So Lawyer Eunice, over to you. Give us your contact details and the address of BWF Solicitors for anybody watching us who would like to contact you.
Thank you so much, Vicky. So as Vicky was saying, of course, a lot of noise has been made about our EU settlement scheme deadline for the 30th of June 2021, which is next month. We haven't got much time. And I think that the more noise we make, I think more people should keep sharing. Because even last week, I had someone in my office who still hadn't done anything about it, because their situation was quite complex and they didn't know what to do regarding making the application. So please, if you know somebody who may need this or who is interested to give this out to somebody who is also in the same position, because they may be an EU national themselves, or they are a family member of an EU national, or maybe they've retained their rights. So they were formerly married to an EU national, or the EU national they depended on has now passed away, or for one reason or another, the EU national is no longer here in the UK. In such situations, please, all of these people have to make their EU settlement scheme applications by the 30th of June, including those that are primary carers of EA national children who are in school, or British nationals who are in education as well. So yes, the deadline is the 30th of June 2021, and so we need to make sure that as many people as possible do not wait till the last minute, but do it as soon as possible. And so, yes, if you need further information or further advice regarding any other issues apart from immigration issues, because we do deal with family matters as well, and some civil litigation issues, please do not hesitate to give us a call on 0208 493 7340. So 0208 493 7340. And then in terms of those who will want to come to the office during office hours, we open from Monday to Friday from 9:30 a.m. to 6 p.m. The office is the 4th floor of Anna House. So we are on the 4th floor of Anna House, 214 to 218 Tottenham High Road. So 214 to 218 Tottenham High Road. And we are in London, Seven Sisters. The postcode is N154NP. So N154NP. Do have a great week, and hopefully next week by this time we will see each other again.
Yeah, on that beautiful Lawyer Eunice, thank you so much. Ladies and gentlemen, we've come to the end of this program. I would like to show my gratitude, thank all our sponsors, BWF Solicitors. Without you, we wouldn't be able to come on every Saturday to educate you. Also, Victim Estates, also thank them so much for their support. Without them, we wouldn't be able to come to you every Saturday. And lastly, Eagle Heights International School is your Maths Fusion Center, who are also supporting us. I know now the weather is getting better. We are approaching summer. So Heritage TV has got very, very, very good packages. If you're having programs or you are planning to have any party or birthday celebration, church programs, what have you, Heritage TV has very good packages to come and cover your event live. Get in touch with us, contact us on all our social media handles, and we'll be able to take you through all the packages that we have. And we'll even show your events live on Heritage TV as well. Thank you so much, and I hope to see you again next week with another interesting topic. Lawyer Eunice.
Hi.
Thank you once again. On that note, myself and Lawyer. Oh, before I forget, oh dear, forgive me. Today at 4:00, BWF's Facebook page has the Community and the Law program, which airs every Saturday for 4:00 to 6 p.m. Today's topic is making a successful application to bring children to the UK. Making a successful application to bring children to the UK. We have so many people who have children back home, but don't know how to bring their children back to the UK. So if you're one of them, please make sure you join BWF Solicitors on their Facebook page at 4 p.m. and you definitely will not regret, listening to this, educative program. I will also be there, even though I don't have to, bring any children from Ghana. But then again, I also always tell myself that when I listen to these programs, at least I will have an idea what is going on, how to go about things. And if anybody tells me, oh, Vicky, I'm trying to bring my child from Ghana to the UK, how do I go about it? Because I always tune into BWF Solicitors on their Facebook page, I'm able to, tell them something about it, and also direct them, because I'm not a lawyer or solicitor. So I will definitely, because I've listened to what has been shared on their Facebook page, I'll confidently be able to, recommend such a person to go to BWF Solicitors for them to help guide with the application for her to bring her children to the UK. So it doesn't matter if these topics, what is going to be discussed doesn't apply to you. But when you listen to it and someone else's, comes to you with such, a problem, you'll be able to, advise them, tell them, this is the law firm that I want you to contact for them to help you with your immigration issues. So please tune in on their Facebook page, BWF Solicitors. And we have Mr. Bernard Owusu with and the host. What is his name?
Mr. Kuku.
My apologies. Yeah. So the two of them will be, taking you through.
And then another one of my colleagues will be guest as well.
Program.
I was just mentioning that another one of my colleagues, Charles Asma, will also be guest on the program as well. Yes.
Oh, wow. Okay, brilliant. Looking forward to it. So I'll tune in at 4 o'clock. I want all of you to tune in at 4 o'clock. We'll meet there live at 4 o'clock, and let's all, educate ourselves as well. Now, let's give our lovely viewers a lovely goodbye and have a lovely weekend. Bye-bye. Yes.
Conscious of the demands of our clients, we always offer a friendly, listening ear and sympathetic attitude. We've worked with thousands of people all across the UK in all areas of personal legal services. We have received great feedback, reviews from our clients. We are located at 7 Sisters in Tottenham on the 4th floor of the Anna House, right on top of the Victoria Line train station, with your utmost convenience. We have a friendly office and provide all of the refreshments necessary while you wait to see a lawyer. Dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence, and conduct as part of our responsibility to uphold the rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society accreditation helps to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. We are solicitors and are here to